Welcome back. Thom Hartmann here with you. A brilliant tweet by John Lewis, the congressman. Do not get lost in a sea of despair. Be hopeful. Be optimistic. Our struggle is not the struggle of a day, a week, a month, or a year. It is the struggle of a lifetime. Never, ever be afraid to make some noise and get in good trouble, necessary trouble. Hashtag good trouble. I think he's differentiating that from bad trouble, but it's a remarkable thing. The news is reporting, well, all the networks now, that Justice Kennedy has said that he's going to step down from the United States Supreme Court, which gives Donald Trump his second appointment in 2 years. This is distressing news. And in large part because the American people don't seem to understand the importance of the Supreme Court. The Supreme Court, if you read the Federalist Papers, Alexander Hamilton talked at some length in the Federalists, the ones that are in the 70s or the low 80s. I think it's 74, but whatever. In that range, you'll find them. He did a series of 5 Federalist papers. They were published as newspaper articles at the time, but what we call the Federalist Papers. He did a series of 5 of them on the Supreme Court and the court system, because he and Hamilton and James Madison wrote most of these. John Jay wrote a couple, and there was somebody else who wrote 1 or 2. But basically, it was Hamilton and Madison, and they were trying to sell the Constitution. This was between 1787, when the Constitution was written, and 1789, when it was ratified. It took 2 years to get that thing passed and basically create a whole brand new form of government here in the United States, do away with the Articles of Confederation and bring in the Constitution. And when they wrote the Constitution and when they were selling the Constitution, there was some concern expressed by a number of people, by the people who referred to themselves as anti-federalists, and Thomas Jefferson was the leader of this pack, by the way. There was some concern that the Supreme Court could end up being essentially like monarchs, like kings, that they would have too much power. And they wanted to explicitly limit the power of the Supreme Court. And their concern, I mean, it wasn't that they were opposed to power in and of itself. They gave enormous power to Congress, the power to make war, the power to raise taxes, the power to spend money. They gave enormous power to the president, the power to be the commander-in-chief of the military. But they didn't, and they wanted the courts to have the power to be basically, you know, the court of last appeal and all that sort of thing. But they didn't want the courts to have too much power because they were not elected. The Supreme Court was appointed by the justices, are appointed by the president, ratified by the Senate. They're not elected. And so there was this concern. And if you read Madison's notes on the Constitutional Convention, which is a day-by-day, you know, summary of what happened and what the debates were, and a lot of verbatim quotes in there, you will see that there was a huge debate over this, over whether the Supreme Court should be answerable to the people in any way at all. And you had the Hamilton faction, essentially. Hamilton wanted the president to be a lifetime appointment. Hamilton actually thought that, you know, having kings was a good thing. The idea of hereditary kings, not necessarily a good thing, but having somebody who was so powerful that they could counterbalance the mob. You know, the danger of democracy, because there was a big discussion at that time about the danger of democracy. This hadn't been tried before in a real meaningful way, the way that they were doing it. That that there needed to be this king-like figure, and when Hamilton said that on the first day of the Constitutional Convention, he was laughed out of the convention. He got so PO'd about this that he went back to New York and stayed there for 2 months, and finally came back later. But he was so offended. But then he argued later that the Supreme Court should have this power, and he lost. And so in the Constitution, it says that Congress can override the Supreme Court. If the Supreme Court says unions can't have rights, Congress can override them. If the Supreme Court says that, you know, the president can have his Muslim ban, Congress can override them. Now, I'm not expecting this Republican Congress to do that, but there's probably a Democratic Congress coming. Let's hope. And I think that Kennedy delayed his withdrawal from Congress or from SCOTUS. He failed to delay it. Had he delayed it, his announcement until after November, then there's a possibility that Democrats in the Senate could have made sure that whoever Trump appoints is at least a reasonable person, not another Neil Gorsuch, who's the most right-wing and extreme member of the Supreme Court that we have seen since the slaughter court, since the 1920s. But instead, I'm sorry, the slaughterhouse cases back in the 1920s. But instead, what we are seeing in all probability now is that the Republicans will just jam this through really quickly. So back to the Constitution, this is something that Congress has not taken advantage of, to the best of my knowledge, in history. Now, there's some exceptions to that. There have been a few times when Congress has passed laws that have court stripping provisions in them. I was talking with Congressman Pocan about this earlier, where they literally write into the law, the new piece of legislation, this law is not subject to review by the United States Supreme Court. They block the Supreme Court. And you say, well, how can they do that? The Supreme Court is the final say. No, here's what the Constitution says. This is Article 2, which is Article 3, which is the judicial branch, Section 2, in which they establish the court system. The judicial power shall extend to all cases in law and equity arising under this Constitution, blah, 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 blah. And then they get to the Supreme Court. The Supreme Court has original jurisdiction in just a very narrow area. Original jurisdiction means they're the first court you go to. In all cases affecting ambassadors, other public ministers, and consuls, and those in which a state shall be a party, the Supreme Court shall have original jurisdiction. So in other words, if New York State sues Connecticut, it goes right to the Supreme Court just like that. That's where they sue Connecticut. Or if an ambassador is involved in some case that ends up, in the U.S. court system, it goes right to the Supreme Court. But everything else, well, back to reading from the Constitution. In all other cases, the Supreme Court shall have appellate jurisdiction. In other words, they're the final appeals court. Some other court has to have judged first, and then it gets appealed to the Supreme Court. It's where the buck stops. It's the final appeal, okay? In all other cases, the Supreme Court shall have appellate jurisdiction, both as to law and fact, with such exceptions. And sort of like the way Donald Trump does his tweets, he's actually borrowing the convention of the 1700s, of the constitutional era. They capitalize the word exceptions to say, this is really important. With such exceptions and under such regulations, and the word regulation is capitalized, as the Congress shall make. So Congress has an absolute power. It doesn't require a constitutional amendment, although that's the way to make it permanent. But the Congress has the absolute power to say, you pass Citizens United, we're going to pass a law striking down Citizens United, and we're going to embed in that law a sentence which says this law shall not be subject to judicial review by the United States Supreme Court. They can do that. It doesn't require anything other than simply doing it. And they can pass it with a simple majority, assuming it doesn't get filibustered in the Senate. And if it gets filibustered in the Senate, they need 10 extra votes. So there is a remedy. And I think, frankly, we should start talking about that remedy, particularly now that we seem to be, sliding back into these insane times.